Item 22 is 10 years conviction under section 4 of POCSO Act. More than 6 years I am in custody, jail custody. Now Supreme Court has said that when 50% or more than 50% has been spent in the jail, she should be granted bail. And there are some other lacunas also. So my humble prayer is Lordship may kindly upgrade the matter, because she is the only member of the family and the entire family is almost ruined. More than 6 years in custody. May kindly be upgraded.
We'll consider. Once you reach the matter of hearing, we'll definitely consider.
Oh, like.
May I please, I beg to mention item number 5. Matter may be taken up next week, my
Why?
lord. Mr. SRS Chaudhary will appear in this case.
These are order matters. Wait for a few minutes.
Yes,
We'll stop the order.
May I please, my lord? But with the consent of the other side, my lord, I beg to mention item number 23, my lord.
No, not at this stage. Yes, go for the matters.
Lordship, kindly the matter may be adjourned if the engaging counsel has some personal difficulties.
You are appearing for the
Respondent.
whether the petitioner paid the maintenance or not.
Not paid.
Not paid.
Petitioner is made under our lordship, as per knowledge.
Since when he has not paid you the maintenance? Since when he has not paid you the maintenance?
Lordship,
After the order.
I'm not aware. From the order, lordship, from the order, not paid any single penny.
Next speaker gonna come. Next speaker gonna come.
Yes, matter was fixed today on presence of your senior.
His
He
lordship,
was aware.
his lordship, he has some medical emergency in his family, that's why.
Yes.
Next week, lordship,
The
maybe.
short date may be fixed, lordship.
Friday, lordship, maybe. Possible.
Okay, on Friday, this Friday.
Friday, lordship.
Friday.
Always.
DPR will be consulted for the list.
Good morning, my daughter.
Yes.
May I table will be taken up after some time, because in this case diary has been called for. Now, whether charge sheet has been submitted or normal, I'm not sure. I have instructed my office to contact the IO, after some time,
Or we'll have it at 2 o'clock. We'll have it at 2 o'clock.
Charge sheet? Next step?
Well, in this case, my report from the IO was called for,
Report.
Yes, matter relates to
Zima vehicle.
vehicle. So when it was seized,
and on 31st of October 2023, madam. Well, kindly come to page 15, madam, on 5. It was, my lord, GDNT, my lord. Basically, my lord, that vehicle was parked, my lord, in front of a, my lord, workshop, my lord. And subsequently, my lord, on the request information of the workshop manager, my lord, the vehicle was seized by the Romeo police, my lord, and subsequently GDNT was made, my lord. It was not involved in any criminal activities, my lord.
Yes, Mr.
My
The report.
report is not received, my lord. But let it also be taken up at 2 p.m. my lord, whether I inquire whether my lord, report has been received by my office.
We have it at 2.
My lord, absolutely.
My
May I please your lordship? Lordship, 482 petition, my lord, file under 227 of the constitution for quashing of the proceedings, my lord, because against the 4 petitioners herein, my lord. The petitioner number 1 is the husband, petitioner number 2 is the mother-in-law, petitioner number 3 is the son-in-law, and petitioner number 4 is the petitioner number 3 is the elder brother of petitioner number 1, and petitioner number 4 is the sister-in-law petitioner number 1, my lord. My lord, here, my lord, before proceeding to the facts, my lord, here the marriage was solemnized on 24/1/2021, my lord.
Yes.
My lord, in this case, applicant was convicted under section 366 and 376, reduced section 4 of POCSO Act, and he was sentenced under section 366 and 4 of POCSO Act for a period of 7 years and 10 years, lordship. Allegation against the petitioner is that he abducted the alleged victim and thereafter committed rape. Police registered a case under section 366 and lordship 376, section 4 of POCSO, lordship. Lordship, kindly have a look at the evidence. Lordship, Azahar. Lordship, paper book is ready. Lordship, kindly have a look at Azahar, page 4 of the paper book. Lordship. Azahar lost after 4 days of the occurrence. Alleged incident took place on 31/2018. Azahar lost on 2/2/2018 after 4 days, 3 days, lordship. May I read, lordship, Azahar?
See, You want, this is your application for suspension of the sentence.
Lordship,
Paper book is ready.
Lordship.
Let us,
Lordship, Lordship may consider the bail clear. I am not ready for a final hearing, Lordship. I take your Lordship a few times, maximum 15 minutes, Lordship, not more than that. Lordship, this was of the bail petition that will,
since the paper book is ready, why should you wait?
Lordship,
Consider that matter.
it will take time. I am not ready also, Lordship, for
Not
final
today?
hearing, Lordship.
22 matter, now I think hearing of 22 are being taken up.
But I am not so ready, Lordship.
That's-
Lordship, one thing, it is a case of abduction, whether abduction is proved by the prosecution. It is their case that he abducted the Alice victim on 30, Lordship 1
During the
2018.
trial, you were on bail.
Lordship,
I did not
that
see
time
the
I was on bail,
During
That
the
time-
trial, you were on bail.
bail.
Perhaps
After the order of the court, on the conviction, you were in, you were sentenced.
Lordship, thereafter, I have been in the custody for 2.5 years, Lordship. Almost 1/4 of the conviction period I have already served, Lordship.
Give us a date, we'll hear the appeal.
Lordship,
Give, not today, if not today, give us a here. Because paper book is there no point of keeping these matters.
Lordship,
Next week? Or this Thursday? This Thursday?
Not this Thursday, next Thursday, Lordship.
Next Thursday?
Next week, Thursday, 25th.
It may be on, any day in the second half.
Lordship, kindly have a look at evidence of PW4. That I'm insisting for that
You are
reason,
insisting for
Lordship.
the bail. Since the
It is there, it is the
ready, that's what you are saying.
prosecution witness, Lordship, what he stated, PW 5 and 9, only 3 witnesses
At this stage, since the paper book is ready, we will take up the matter. You can need date you want, 22nd, 23rd, to next Monday also we can take.
Lordship, then it is after 1 month. Not possible for me next already.
And
Give
this
us
is
a
a
date.
small,
Lordship,
this, no.
Any date after, Lordship,
So the calendar and give us a
Lot-
date, we'll
lot-
hear it and we'll.
Lordship.
Because there are only 11 witnesses. Can finish it.
Lordship may,
Any-
maybe on 30th,
Tuesday or Thursday.
Lordship, next week,
Any,
not possible.
you fix a date. any
Lordship,
Tuesday and Thursday.
Maybe on in the month of August, Lordship, any date, on Lordship,
1st of August?
27th
27th.
of August.
27th.
You would not possible.
Yes, if the appellant wants 27 August or 29, got it.
Otherwise, statements are consistent of the victim.
We'll go to that. We're not in the merit.
Not a case for bail, what I am suggesting. Hearing 27th of August. মার্কআপ এখানে হলো এফআইআর করতে যখন মার্কেট বুঝছে কিন্তু ইহাতে তো একেলগে বুঝছে ইউরিনেশন কারণে
আপনার নাম দিতে স্কুলের নাম বলে একটু নাম দিন কিন্তু মেইন
With I criminal. Okay. The criminal appeal was admitted on 07/02/2020. Okay. Since
এখন আর টাকা
that the registry has already
Good
received.
idea,
the
good
relevant report,
ওকে রে সইন করবো না Will not agree with it.
Special within the two into three of the 2018. Only landed additional system. Some special. Paper book has also been ready. Okay. Total for the applicant and one. The petitioner, the applicant has also.
Both sides.
The applicant as an applicant has also filed connected, has also filed. I put in bracket 48 to 20. Praying for suspension of the sentence. Operate. Operation of the impugned judgment in order to get 20/12/2021 was violated. Special judge Kasai Censor in the same judicial bracket in by which he has been convicted under section 366 or 376 IPC, read with section 4 of the POC respect. And he is presently undergoing the sentence. Of rigorous imprisonment for period of 10 years. With fine of in the fall simple imprisonment for 6 months. For the offenses under section 4 of the POC Act. And also rigorous imprisonment of 7 years with fine of rupees in the fall simple imprisonment. Section 366 of the IPC in terms of the impugned judgment and order dated 2012-2001. Considering entire aspect of the matter. It is decided instead of considering the interrogatory application of the appellant for suspension of the sentence imposed upon him by the impugned judgment in order 2012-2021. The entire matter considered as acted by the parties list on 27/08/2024 for it. That's
Deeply obliged.
All right.
I'll make it over.
Madam, adjourn for the day, madam.
Anyone appeared for the response number 2?
Lordship, Oxon, Oxon, 326. It's respond number two, otherwise not required. I have an objection, listen.
Yes, he's taking time. Let it be.
Next week or whenever.
What's your good name?
My lord, A. Ahmed. A. Ahmed.
Appearing for the applicant appellant. Rachel, list after 3 years. And it becomes part of it.
My lord.
Yes,
Lively's lordship. We have submitted affidavit regarding Dastu service lordship. This time we have served in presence of one witness from the respective school, but only thing is lordship, as per the order, all the notices was to be served by 20, on or before 26. So two, on respondent number 6 and 7, we could serve on 26, rest on 21/6, 22/6, and 24th. In presence of witness.
yes, anybody appearing? You are appearing for NC Hill.
Yes, sir.
Pursuant to the order is 06/06/2024. The review petition is took steps on the response number 428 by Justice Service. Serving copies of this review petition to them on 24/06/24, 20/06/24. 24/06/24 within the particular number 20/06/24 within the particular number 21/06/24 within the particular number 7 and 22/06/24 in presence of obtaining their signature in presence of witness. And thereafter file an affidavit in that regard on 26/06/2024. How the respondent numbers 4 to 8 have not appeared in the matter, have not yet entered. Okay. What's your good name?
Diego Goylord.
Understanding counsel for the NCL respondent number, standing counsel for respondent number 1. Will be representing 1 to 3.
Yes, Lord, sir. One.
Anyone from the finance or anyone?
Number 9.
Standing counsel. Namtulelu. Anyone representing finance? You go. Mr. Purakasta, will you wait for some more time? Today is the date fixed. We'll have it 6th of August or 5th of August. Better the 6th of August. Let's this matter of 6th. If it doesn't appear, we'll proceed.
Obliged.
Service of the service of notice in the respond number. List on. So the review petition has been admitted.
No, Lordship, this is a delay petition, delay application, 28 days delay only.
We'll have it on 6th. Pass the order. List on.
Obliged.
No representation on behalf of the petitioner on the name of the council. council was it part MS Chennai Council Department of School Education for the Assessment from 1 and Mr. B. Deori, let it know that we get some for the assessment. List after 2 weeks. So that it took weeks.
They will not. Okay, the conducting council is out of station. This matter may be taken after 1 week.
In the office note. 03 097 2024 it is seen that the registry received by the ID card pertaining to response number 3. On perusing the ID card, it is seen that one Boroha suit, BARASHA suit received the notice of this review petition but the said ID card is without any seal of the concerned higher secondary school. It is also not known whether said Borosa suit is the principal of not HS School Sonitpur or not. In view of the above, petitioner is directed to take first step in response number 3 by raise the post actually providing its correct and proper post stems on or before 24/07/2024. List after 6 weeks.
If you not. The last occasion we were asked to take a step on response number 2. We have already taken a step, Milord. Service is awaited, Milord. Let the service be completed. Also, Milord, on the last occasion, there was an interim order that may be continued.
Heard Mr. A.W. Aman, my counsel appearing for the petition. And
K.
Mr.
Bush,
K. Bushel and additional public prosecutor. Some for respondent number 1. Pursuant to the order dated 4/6/2024. Asked earlier in this proceeding, petitioner has taken steps to the respondent number 2. And notice was sent to the respondent number 2. On 11/06/2024. Petitioner is directed to serve a copy of this revision petition in the office of the public prosecutor, Assam, Guwahati High Court. For service of notice on the respondent number 2. Obtaining necessary acknowledgement from the said office with date, seal and number. Such steps shall be taken by the petitioner on or before 20/07/2024. The office of the public prosecutor, Assam, through the authorities of Moirabari Police Station, District Morigaon, shall serve a copy of this revision petition.
You've already done it, Mila.
This time you have to take it to the office of the public prosecutor. In Guwahati High Court. To the petitioner, Moirabari Police Station, on the respondent number 2, MS Saleha Khatun, wife of late Zanhabad, resident of village Borthor, PORT, Kochari Gaon, Police Station, Moirabari, District Morigaon. Placed on
Interim may be continued, Mila.
28th of August. Till then, the interim order passed earlier on 04/06/2024 shall remain in.
Deeply obliged.
Petitioner. No representation on behalf of the petitioner on call. The name of two counsels have been reflected for the petitioner in the cause list. List again on 23rd July. failure on the part of the. No, failure. If on the next date, the petitioner remains unrepresented, court shall consider to vacate the interim order passed earlier on 21/06/2020. Yes.
Maybe, Lordship. Lordship, as per office note dated 11/7/24, Lordship. Service is evident on respond number 2, Lordship.
The office note it is seen that notice was issued to the respondent number 2 by registered secretary on 21/06/2024. Rate service report. List on. 12th August. Till then. The interim order passed earlier. 10/06/2024. Shall remain in force.
Lordship, I have a prayer, Lordship. Same petition and the same respondent. Another two criminal petition is pending, Lordship. So when the Lordship, that may be taken with this matter, Lordship, for proper adjudication, Lordship. Case number is there, Lordship. Finally.
Other notice have been issued in those cases.
Yes, Lordship, everything has been done, Lordship. Criminal petition, Lordship,
List along with
662/24 and 664/24, Lordship. Both the same petition respondent. Deeply, Lordship, deeply. Lordship.
as the parties to the present proceeding are same in those two. Just a minute, just a minute, just a minute. Just a minute. There are CBI matters are pending. Who is appearing for the CBI?
Lordship, I am appearing for CBI.
How much time it like? Because it's a serious matter.
It will take time. Take the whole day, I think.
Not even in holiday.
It will not.
This is
43 witnesses are there, my lord.
43.
And there, I think 6 and 7 appeals are, my lord, out of the same judgment pending. In one of the appeal I am appearing, in one of my friend. Tumi keta debe. In 3 appeals, he is appearing, in one I am appearing, and in one probably Mr.
Yem Chaudhary.
This matter was hard one. My lord, Mrs. Justice Rumi Pukar, but could not deliver the judgment, could not complete. We have submitted our written submissions are also on record.
Again, it was hard by Susmita.
Then thereafter the matter was also heard again, then.
So it can be placed before the appropriate court if it was heard
Susmita Phukan also had it
at length.
at length.
To some extent.
Lord, let it come up. We have to argue on minute. It's an old matter.
No, since the matter was hard, if so, if you desire, then it can, we can submit that the matter was earlier heard by justice.
Susmita Phukan count.
No, prior to that, anyone heard?
Yes, ma'am, Mr. Rumi Phukan.
Earlier
She
to,
got written.
Yes, we can pass an order. If you agree, then
Yes.
it will come up to before Madam Phukan.
wherever, my lord.
We can try one luck.
Wherever it comes, my lord, everyone.
No, file, eta file.
Lordship scam, Lordship.
ঠিক হবো না?
Down, right, down.
না, জানো মনে হয়, তোমার কাগজে কইছে।
Down, look, better try, look,
তোমাকে রাতিপুৱাই কৰি দিলো। একেবাৰে যাই
Earlier it was Pathat, then it was released from Pathat.
Release from part. It's no longer part time.
Because 3 months also, 3 months you can.
More than three.
No longer part time.
To lapse of time, I know.
এবং স্পেসিফিক নকৰি পেলাই eligible for appropriate bench কৰি দিলে ভাল নেকি আৰু সেইটো better.
In fact, she has prepared a note here also.
I think
And it counsels for the parties. Namely, Mr. K. Agarwal and its senior counsel. Mr. P. Kotoki. You are appearing in which item? Mr. B. M. Chaudhary is there?
Yes, madam.
Mr. B. M. Chaudhary. Anyone representing B. M. Chaudhary?
Not here, madam.
And Lanet CBI counsel, Mr. M. Haloi. Submitted that this matter was heard at length earlier by Honorable Mrs. Justice Susmita Pokand. At one stage, the matter was heard with his lordship. MS. Justice MS. MS.
হলে বেটাৰ হ'ব জাজমেণ্ট মই পঢ়িলো
View of the
জানো মিতালি আছে
whatever, this criminal appeals of pending since 2008. Considering the above, the registry may place the matter before his lordship Donald Sutton in his administrative side. Bring it to the of his lordship.
মানে প্ৰেজেন্ট 3 বছৰটো আৰু হয়তো দি দিব পাৰে ইমান লাগি নাথাকে
Thereafter. Full stop here. Thereafter. As per the order of the matter.
নীতিন আৰ্গুমেণ্ট দি পেলাই লেখা শেষ কৰি থৈ দিম আৰু দি দিম নীতিন আৰ্গুমেণ্ট দি পেলাই লেখা শেষ কৰিব লাগিব
If because we do not have in power, if lordship say passes an
no, it will not be
administrative places before the madam.
That's what
comes
I
and
was
then-
actually I told you.
And if it is placed before this court will take up.
Yeah.
Okay, whatever, because
The lordship fix it.
we cannot fix it.
Yes.
Come on.
90. Yeah, please always. Lordship may agenda matter for a week, matter will go through madam. It's a provision of fund, my lord. Headmaster, my lord.
Yeah.
Day after tomorrow.
After tomorrow. Same day on Friday, my lord, Friday. God bless.
Prayer of the council. 18 to 40.
God bless.
May it please the lordship. Lordship, in both this criminal appeal jail, I am appearing as an amicus. My lord, actually, my lord, both the appellant have already released from jail hazard on expiry of his sentence after setting of measure period and remission hour. And also, my lord, they have also paid the fine also, which was imposed. To that effect, my lord, may kindly have a look at flag D. Flag D is the letter.
What about the other appeal?
My lord, in both the appeal, my lord, both the accused person, my lord, it's arising out of the same judgment.
No, one is Babu Das.
Yes.
The other is,
Other one is Biman Bora.
is there any such letter for Viman Das?
Yes, my lord. Biman Bora, my lord. Biman Bora was out of jail. And sentence was over.
Where is that letter for Viman Bora? We have seen the letter of Babu Das only.
My lord, there is, my lord, that, my lord, I have note down, my lord. That report is also there, my lord.
Is it?
Yes, my lord. Or my lord may clear, if your lordship is peruse the order dated 8/6/2023. Because as per that order, my lord, report was called for whether Babu Das is still in jail or not. As the Biman Bora is already out from jail.
Regarding Viman Bora, there is no such.
My lord may kindly see the order dated 8/6/2023.
বাপু দাস তো
But that letter of the superintendent is not here. On the basis of which the court passed that order. Anyway, just a minute, let us check. Yes. Heard Mr. M. Doctor and counsel appearing, amicus curiae. For the appellant. Biman Bora. Alias Biren. Was convicted and sentenced to undergo rigorous imprisonment for 7 years under sections 395 of the 397 IPC, fine of rupees 3,000. In default of fine, simple imprisonment for 1 month. In terms of the judgment and order, dated 16/11/2017, passed by London Additional Session Judge Golaghat in Sessions Case number 111 of 2012. Arising out of Bokakhat Police Station Case number 36 of 2012. The Superintendent of District Jail Sibsagar and Rikati. The Superintendent of District Jail Sibsagar, wherein the appellant was serving the sentence in terms of the judgment and order dated 16/11/2017 with the report. Is it 16 or 10?
Hello?
16/11/2017 or 10/11/2017?
এটা দেখতে ভালো বলে না এটা এর ব্যাপার কেন দেখছি এখন তুমি ডাউন কইলা
Selection, appeal and by communication under memo number as DZ oblique 8 oblique 2023 oblique 813 dated 26/05/2023. Inform the registry of this court that the convict appellant, state convict appellant, Biman Bora, take your seats. Take your seats. Was admitted on the said date on 10/11/2017 in connection with the said session case number 111/2012. এই আগত যে লিখিছা দিন বিকেট পুলিচ কেছটোৰ আগতে পুলিচ কেছটো দিছা না বোকাখাট পিএছ কেছ লিখিব ইয়াৰ কেছ নম্বৰ 354/2000 had already been released from the said jail, Sibsagar jail, Sibsagar district jail on 17/02/2021 on expiry of the sentence with the benefit of hazard period. In view of the I got really this criminal appeal being in proxus stands closed. Though the court admitted this jail appeal on 21/03/2018, but they said sentence imposed upon the appellant on 10/11/2017 Maryland Additional Session Judge Golaghat was not suspended. In the meanwhile, the accused appellant already completed a term service sentence. In that regard, the superintendent of the is reserved by communication number taken in view of the above. This similarly, next the appellant say to Babu does same order by communication Babu number ZDJ.07/2023 dated 04/07/2023. Communicated to the registry of this court. The receipt convict Babu Dutt have deposited the fine of rupees 3,000 in the court of district and session judge Golaghat by dated 11/08/2022 and was released from jail on 28/09/22. On expiry of his sentence after setting off the hazard period and remission on Same. One. Registry cell. Row. One city. Or one city. Registry cell return the records of this one's case number 111 of 2012. Their case number 5. Bokakhat police number to the court of London additional session judge Golaghat. Court allow what copy of this was. And the copy of the communication. Bottom to click communication. Dated 26/05/2023 of the superintendent. Figure. Issue to along with copy of this record. First case to the record to the second case to the communication of the superintendent police. Second one. Along with the copy of this one. The second case. Photocopy. Record along with the copy of this order and communicate to the first or into second file. Okay. The registry cell pay the remuneration to the learned amicus for Mr. M. Dutta on raising the bill.
Deeply obliged.
Come back at 2. My lord, may kindly take a 2:30 because another matter is fixed. 2:30 kindly take. I'll not take so much time.
Doesn't matter.
2:30. How late?
In this case, charge sheet has been submitted, Lord. Yes, yes.
Yes, ma'am.
Yes, my lord. If success is given, then I want another date for filing affidavit. And I will taking the substitute record for another date. I want
Or what?
for affidavit, filing affidavit. That's it.
The charge sheet has been filed. Should we interfere here? Under 482? Get up.
I will file another affidavit, additional affidavit, my lord.
Charge sheet was filed before filing this petition. This petition was filed in May 24, I think. And charge sheet was filed on 20th January 2025. Now, after filing charge sheets, there will be hearing on charge. The petitioner will get full opportunity of being heard at the time of framing of charge. If there is no prima facie case against him, my lord, he will be discharged by the my lord, learned court below,
In which,
trial court,
in which date, January?
January, 20 January 2024.
Under which section?
My lord, sections are not given.
Section.
Otherwise, the case was registered under sections.
See,
Yes. 417, 419,
406.
406, IPC. But 376 is not there.
When this charge sheet was filed?
Charge sheet was
January.
filed on my lord, 20th January 2024. And this petition was filed in May
May 3rd,
2nd,
3rd May.
affidavit note 2nd of May. Affidavit 2nd of May.
Acha, acha, acha. Third May.
Hmm?
Date of filing.
3rd of May. Petition was filed up 3rd of May, so much later, 24 of 24. I have received your WhatsApp message from the IO.
Third, MSM Government Council appearing for the petition. And with the additional public prosecutor appearing for the state. On instruction. Non-additional public prosecutor. Faraghat Hassan. While issuing notice. The court on 17/05/2024. In this proceeding. Would call for the scanned copy of the relevant case relating to Jalukbari PS case number 611 of 2023. While valid as phone number 2 against the present petition. On instruction. Non-additional public prosecutors are submitted before the court. In that. Way back on 20/01/2024. After completion of the investigation of the case. The authorities concerned submitted the charge sheet. With regard to inside Jalukbari PS case number 611 of 2023 involved in this petition. Jalukbari PS is corresponding to the number 7802. stating that this criminal petition was filed only on 02/05/2024. On the next date fixed, the respondent number 1 shall apprise the court. Do you have the charge sheet number?
Yes, my lord. Charge sheet number 24/2024. Dated 20, stop
20/01/2024, right? 20th January.
20th January.
Shall apprise the court. The status of the said GR case number 7802/2023. After filing the charge sheet on 20/01/2024. And the sections under which said charge sheet has been filed against the petitioner. By next week, it will be possible for you.
Sorry, my lord.
By next week, you'll be able to let us know the status of the GR case
Status
after
of
filing of the charge sheet.
that have to be called by the registry only, my lord. Because after filing charge sheet, we do not have any hand in, my lord. It becomes court matters.
Registry
Yeah, any notification.
of the instructor. Jalukbari, right?
Jalukbari PS case.
Jalukbari under the CGM Kamrup only.
Season Kamrut. Season Kamrut na hogi.
Season Kamrut.
Oh, yes.
CGM Kamrup. Representative status of the GR case. And the list on 7th August.
My business may be recorded.
Yes,
also.
sure. Take it. একেলগে লিখিব 1 and 2 কৰি madam. Yes.
Apply, my lord.
7th August may not be possible in that case because today is 16th. Okay, second, 7th August. 7.
7th August.
Because
Lesson 3, what is the information?
Three minutes, I have not received information. But I tried hard, my lord, to contact the concerned IO. But otherwise, Zimma of vehicle, my lord, the law is settled by.
It's very well settled, but
Well,
thing is, this
settled.
report will be required. If the IO doesn't need for any investigation,
Yes, yes.
otherwise you can dispose it of only for that report of the IO.
We sent one message on 20th of June, but no report has been received, my lord. My lord, may I pray for 1 or 2 days' time so that I can contact him? I could not contact today, my lord. He is supposed to.
Friday, my lord.
Tomorrow, day after, my lord. But
Let us know by 25th,
25th of July. My lord,
right? Next Thursday. We'll dispose it of otherwise.
my lord.
List on 25. 07/2024, enabling
No? 25th.
just mayor GD entry. It has
Yes,
been,
surprising, my lord. Actually, this happened, my lord, only because that, as per statement, vehicle was produced before the magistrate. And therefore, my lord, section 451 came. Otherwise, that could have been released had it not been produced as per High Court's order, my lord, High Court judgment. Because our High Court judgment says, my lord, during the course of inquiry, under section 457 only, my lord, release can be made. Not under section 451. And that is the only conflict.
By this time, definitely, some
Only-
case might have been registered. Merely on the basis of GD entry, whether they can detain a vehicle for so long.
Exactly, my lord.
My lord,
Not possible.
in the both the orders, my lord, only GD&T is there.
My lord, Sundar Bhai Ambala's case is, my lord, regarding, your NDPS case. In
That's
that case,
different
even, in that case, even, and here, there is no case at all.
Listen, Satyanar Likiva. Enabling the concerned investigating officer.
Hmm.
To place the relevant report. Relating to the vehicle. Involved in this matter. That has been seized. On. 31/10/2023. Person to the Romania PS, the entry number 27. dated 31/10. Copy
25th
of this
of,
order be furnished to Mr. For his necessary, get the information.
Mal, obvious.
Pursuant to our, pursuant to the order. Dated 07/06/2024. Australia. Look at the rest of 2024. No, no. Getting it like. Make up the report with me. News and news. Next one. 24. No, 24. I know to the portal. Yes, Ms. Jahan. The next case,
22.
23.
Acha, 23.
May I please, my lord? I mean, item number 22.
22.
This is section 10.
22, I mean 23, my lord.
The 23, what I feel is her statement, there is contradiction. As far as the marriage goes.
See, please come to the paper book is ready, right?
Yes, it's with me.
Judgment it is 2537.
Mm.
Yes,
Yeah.
sentence you'll get at page
At page 36,
36.
35, 36. 3 years under 354. I can't remember a second. 354, 3 years.
Yes.
Yes.
Then
Then 10, section 10 of POXO.
many letters came. In fact, earlier also the superintendent of district jail passed sent the communication. Somehow it was not placed before the
Councils missed it. As far as, of course, this is not a case where he would have, I mean, if had it been a consecutive sentence, he would still be there. But as far as section 31 concerned, I think if it is not mentioned specifically that it is concurrent, it has to be.
It has to be concurrent. There is judgments. It not after that, one after one, it will be add-on. It has to be sentences are always concurrent.
Section 31, Lordship can say 31(2). It will be consecutive if not mentioned as concurrent. And there is a judgment recently by the Honorable Supreme Court.
Is it? But our High Court have passed earlier judgment, you know, that it has to be, if it is not there, it has to be read concurrent.
I think section
31,
31(2), I think I'll also have to take it. They have said. Look at it. That's the same. Oh, it was a judgment.
No, my lord, no, please.
In the case of consecutive sentence, it shall not be necessary for the court by reason only of a 7 in excess of which it competence. No. Because it will be unless the court directs that such punishment shall run concurrently. 31(1), in fact.
in that case, it will be 8.5 years, right? But
8.5 years is also over
no, it will not be.
Oh.
17.
The, in default.
in default to take it.
But here is, see the sentence at section 31.
Hmm. But in the judgment that I'm seeing what, there is one finding that in case of Sessions Tribal, this 31 will not be applicable. I don't know. I have to again go deeper.
The,
Before people really tell me it no. মই তাকে ঠান্ডা রোল তাকে কইলে নহলে ইমান দিন কেনেকে হ'ল হা অঁ এনেকে আকৌ এৰেষ্ট কৰি আনিছে তাক মই কাৰণে প্ৰথম মাত্ৰ নাইট itu তোমাৰ মোক কিয় সোধা
one judgment I remember of Justice Gogoi,
আচ্ছা
I don't know whether it is reported or not, because there are lots of differentiated with the life. Life means life, life is not 20 years,
হ্যাঁ
right? That was one judgment. In that particular judgment, there was a decision that if it is not, even it is not written, it should be reviewed concurrent. That
Huh.
was the finding, that's what I remembered.
Even I was under that impression, but Lordship, I have taken out one judgment of recent 2021. Lordship can see this, paragraph 13. I couldn't mail it because internet is not working. That paragraph 13, here it is said it has to be consecutive. But again, they have made a difference between Sessions Tribal and Tribal by Magistrate, smaller offense. Paragraph 13, Lordship can see once. This is by Honorable Supreme Court in the year 2021. Oh, Sunil Kumar. Seventy-one of IPC. Section 71 of IPC. মোৰ একো নোটে কাম কৰা নাই মই মেইল কৰিব নোৱাৰিলো section 71 কি হয় কি হয় পাইছো where anything which is an offense where anything which is an offense is made up of
Ms. Zahan, in which para it is there that if it is by the sessions tribal, it will be current.
yes that
Where-
difference is
Which
made
para?
it's made in it's there after paragraph 30 So doesn't make it- It is the 13 of resort sound no session query last paragraph nahi
Last paragraph of the judgment.
Last paragraph, the final conclusion, they have said, while closing the matter, we deem it appropriate to reiterate what was expounded in Nagaraja Rao, that it is legally obligatory upon the court of first instance, while awarding multiple punishment of imprisonment, to specify in clear terms as to whether the sentence so and so. And even before that. Oh, pass it, was it? Sessions, Mark?
No, this, that's why I'm saying it has to run concurrently. That's what was the observation made by Justice Gogoi's judgment.
Acha, acha.
While considering the life as a life, because at one point of time, Justice Gogoi used to take all criminal appeals. There, the judgment was passed. I remember very well. And then,
Yes. Lordship will see 7.5, paragraph 7.5. The learned counsel Pai, while frankly pointing out the observations of Constitution bench in so-and-so, to the effect that subsection 2 of 31 has no application to a case tried by the sessions, nor subsection 2 forbids a direction for consecutive running of sentences awarded by sessions. Apart from that,
no, not-
hmm, they have gone to 31.2, 31.1 ওটা আছে না? 31.2 difference rules. It shall not be necessary for the court by reason only. Let me find out the Justice Gogoi judgment then.
No, it is very much there, like, because here, because life is not 20 years,
Huh.
life is life, and that is what we have said. And
Mm.
in that judgment, it is very well said that it is that if it is not concurrent,
Mhm.
let us see just 1 minute.
But in this judgment also, in bracket, they have written where there is no life sentence. Doesn't bracket have to- when there is not life sentence? Oh, go to Sasu.
No, I don't think so. That is,
Mhm.
because, section 31
Hmm.
comes under part, chapter 3 of the CRPC.
Hmm. Yes.
And chapter 3 doesn't, it means court.
Hmm.
It doesn't specify it's a sessions court or it's a court of
Mm.
other magistrates. Court will
Mm.
come definitely the sessions court,
Hmm.
right? So in that case, the submission, though it is stated that the Supreme Court in the Constitution bench has decided some other way, don't think.
Acha.
Because that was not the observation made by the court, it was only a submission at
Ah, ah.
7.5. But there is no such observation by the court.
No observation, yes. But last paragraph, what they say is first instance, court of first instance.
This is a court of first instance, is required to say
Ah.
it is concurrent or it is consecutive, right? One
Mm.
after another, or it is
Yes.
concurrent. It is the duty of the first
Mm.
instance court to specify.
Hmm.
It has not been specified. If it is not specified, then 31.1,
31.1,
it has to go consecutive, one after another.
one after another. Unless it is written, so
Yeah.
consecutive.
If it is consecutive, that means he has not yet completed the term.
Hmm. This is what. But let me dig deeper.
I
Lordship will-
think it's a good thing because otherwise, look into that judgment of Justice Gogoi.
Ah,
if you
yes.
remember.
No, no.
Whether it has been reported or not, I do not know,
Mhm.
because I had never looked into one. Because I heard in this court, it was
Mhm.
in court number 2, I remember.
Hmm.
So find out.
Yes,
And
not
this
tomorrow,
also
day after.
Thursday.
My lord.
Lordship. Tomorrow is
Thursday.
Moharram, so I might not come. So day after.
Thursday.
Lord-
Thursday. Thursday
Not-
we'll have it Thursday.
Thursday.
Or Friday.
Hmm.
Because that is why the issue was in that particular case before Justice Gogoi, this issue cropped up.
Acha.
Because sometimes it was found that after completion of 20 years,
Hmm.
accused
Hmm.
complying with the sentence is to be released, then it is a no, life is life.
Huh.
It's not 20 years, and they are in the case.
In that
Find out, it is
context.
there.
Lordship,
Board
I'll
case.
find out day after.
You also find out.
Yes, my lord.
Ask Mr. Patel to look into it.
Well, can it be on Friday, my lord?
It will be on Thursday, the hearing day, why you want to find? But anyway, if it is prosecuting, then he has to undergo, of course,
Few
will subject
more-
to the outcome of the appeal. in that case.
Yeah.
Or otherwise, he has to be released.
Yeah, portal.
Mr. Mahmood, let it, we'll try it on Thursday,
like-
your case. Anyway, we have to rise early today because of the reference.
15 minutes.
So within 15 minutes, we don't think so we'll be able to complete it. We'll have it on. Thursday.
Otherwise, Supreme Court judgment I have where it is said, beyond 5 years, if
Very-
somebody stays for 5 years and the trial, appeal is pending, then bail needs to be granted. That Supreme Court judgment I have.
I need only
When the
five-
appeal is pending,
When the appeal is pending.
but here is a already judgment is there,
No, appeal
No.
before the High
Appeal
Court is
before the
pending.
High Court.
appeal before the
Yes,
High
High
Court.
that judgment we do have. 5 minutes only would be
2015.
necessary.
No, but in your case, whether paper book has been made ready,
Not necessary, my lord. This is not necessary.
a single, but yes. you-
Already LCR has received your lordship. I have flag marks, all medical examination,
hear.
PW.
We have, if the matter is, record is here, why should you wait for it?
For the timing only, we are for bail malice. 6 years already elapsed out of 10 years. So we are
When
covered
did
by
you- Appeal is pending since when?
since 2018.
But it's already been,
But it was not mentioned.
it has been right. You also get ready for the hearing. Get ready for hearing.
That maybe,
POXO case, right? So POXO case, why should you keep it pending for no reason?
no, Supreme Court judgment is common, my lord.
That's true. That is true. That is we are not saying. This is a matter is already.
But lordship,
tried.
day after tomorrow only,
You also-
bail matter may can
We'll
be
read the
considered.
evidence, we'll see. We'll read the-
Bail matter. My learned friend is also aware about the law. That law, the Supreme Court has laid down.
about 23 to liquor, 22 liquor. List on 4 KT,
Thursday, Lordship.
Thursday.
Lordship.
Your lordship, kindly my presence may recorded your lordship for respondent number 2 as amicus curiae.
M.A. Mahmood, appellant, M.S.S. Dahan. He does. 23 liquor. B does on behalf of respective.
He does.
Mr. M.S. Dahan. Or R1. And Mr. P. Saikia. Yes, Mr. Saikia, you are appearing for here for the victim, the informant. Legal aid counsel.
Earlier one, yes.
Item 23.
For bail hearing, my lord. For bail hearing.
389.
Kindly consider it.
For 22, it is, hasn't
My-
come
my
for,
lord, my house
it has
is
come for
already there.
hearing, not for bail hearing.
My lord, my house is.
We'll
al-
hear it, we'll hear it. Get ready, we'll hear it. We'll take it.